All right, folks, looks like we are live. I'm George with Solo Suit, one of the founders. We also have John Skiba is joining us today. Let me go ahead and get him on the screen here. Just one second, John. Alrighty, there we go. We got John on the show today, so glad to have him on. Let me go ahead and make sure that your audio is good as well. Let me just do something real quick. For sure. Thank you. Alrighty, folks, let me know if you can't hear John. It looks like some people can't hear you. Let me just make sure. I think it's going to be on my end. I'm going to fix the sound here.
We got no sound across the board, or just me?
I think it was just you. It sounds like it's working now.
Okay.
All right. John, go ahead and tell us a little bit more about your practice.
Sure. For those who didn't hear, I'm an attorney in the state of Arizona, doing mostly consumer debt, bankruptcy, defending against debt collectors, debt collection lawsuits, those types of things. That's the bulk of what I do all day long.
Okay,
so.
Great. Looks like sound's working now, so I think we're good. All right,
Perfect.
Folks, thanks for everybody hopping on. We have a lot of people here on the show today. Reserve quite a bit of time for the end for questions. So go ahead and put any questions that you have into the chat. So if you have a question about your case, just go ahead and put it into the chat, and we'll try our best to get to that at the end. Also, just a little disclaimer, we aren't your attorneys. I'm not an attorney. John is an attorney. He's licensed only in Arizona. Solo Suit's not a law firm. We aren't your law firm, and we aren't providing legal advice. We're just doing a little webinar here. So I'm just saying those things for regulations' sake, and go ahead and put any questions you have into the chat. We're going to be talking about the motion to compel arbitration today. So that's a document that's offered on Solo Suit. John also uses it in his practice from time to time. So we're going to be answering the question, should I file a motion to compel arbitration? We're going to be helping you answer that question. Also, we have the link to Solo Suit. This link supports John at the beginning of the chat. If you are using Solo Suit, you can go ahead and click that link and then use Solo Suit to respond to your lawsuit or create your motion to compel arbitration. All right. So John, what is a motion to compel arbitration?
This is something that is in almost all credit card, the terms and conditions, all the fine print that none of us read when we get a credit card. There's usually an arbitration clause. And what an arbitration clause is, I can tell you why the credit card companies put that in there, is it's their way of really trying to avoid class action suits where a bunch of consumers get together and come sue them. But it also has a term in there that basically says that either party to this credit card agreement, whether it's you as a consumer or the credit card company, they can resolve their disputes through private arbitration. Private arbitration is kind of like rent a judge kind of thing. It's this private, essentially kind of court system that helps people to resolve disputes. One of the biggest ones is the American Arbitration Association. It's a private company. It's not a court process, but it's something where instead of resolving the disputes through lawsuit and dealing with it in court, there is this process where you can hire this company to help you to resolve the dispute. And so how you do that is if a creditor sues you and you decide you want to go into arbitration, and we can talk about in a minute why you would want to do that. But if you decide, hey, I would rather resolve this and deal with this matter in private arbitration rather than going through the court process, you can actually file a motion with the court, essentially asking the court, hey, this term in the credit card agreement says I don't have to be here. I want to resolve it in arbitration, and ask the court to either put the court case on hold or to dismiss it completely and allow you to get out. So that's when we talk about compelling private arbitration, that's typically what you're talking about.
Okay, great. That sounds good. So basically, it's like a private court, like outside of court. That's a little bit easier than real court. Is that kind of a way to look at it? Nice.
Yeah, and the rules are much more relaxed. Even like the rules of evidence, rules of procedure, they don't even really apply. They have each of the companies have their own set of rules, but I did an arbitration about a month ago, and the arbitrator was in jeans and a t-shirt. So nice. He's an attorney, he's a professional arbitrator, but it's a much more relaxed environment to resolve disputes.
Jeans and a t-shirt's nice.
Yeah.
Great. When can you file a motion to compel arbitration?
The timing of the motion, I can tell you this. So if you look at the first thing I tell everybody to do is to read the actual arbitration clause. You're going to have to go through it slowly, make sure you understand what's in there. And where you're going to find that is in the terms and conditions. If they've already a creditor's filed lawsuit against you, they may have attached this to the complaint or the petition, or they may have provided to you with their initial disclosures. If you don't have a copy, there's a whole database of these at the Consumer Financial Protection Bureau's website. They have a database of credit card agreements where you can actually search by the name of your credit card. You can go there and you can download it for free. And so I often do that in my practice. If I have a case where I don't have that, I'll go get a copy there. And you can read it, and it will often tell you when the time frame when you can file it. Most arbitration clauses that I have reviewed, and we've looked at a lot of them, they say you can ask for arbitration at any time up until either the trial begins or if a judgment's already been entered. And so, if trial starts, you can't just say, hey, judge, never mind, I don't want to do this. That's too late. My experience is also the sooner you do it, the better. I've even recommended at times people will file the motion to compel arbitration instead of filing the answer. If it was denied, the court will give you an opportunity to file the answer. It's not a huge deal if you file the answer first. And sometimes, if people are nervous about it, I'm like, just file the answer and then you can file your motion. But you don't want to wait too long. Like if there's a motion for summary judgment pending or something like that, much less likely the court's going to grant it, whether they're legally right or wrong. My experience is the longer you wait, the less likely it is the judge is going to grant it. So I would recommend filing it soon. It can be filed as soon as, within the time period after you get served. Or if you file the answer and you're a month into it, you can file it at that point. Sooner the better is my recommendation.
So is there a hard cutoff on when you
can't hard cutoff?
File it any longer? Yeah.
Yeah, if there's, like I said, if you look at the actual terms and conditions, it's going to say in there, if trial has started, it's too late. Or if it says a judgment, if a judgment's been entered, it's obviously too late. You can't say, never mind, let's unwind this whole thing. At that point, you've waived your right to arbitration. I have seen judges even say, if they have filed a motion for summary judgment, which is essentially, the creditor's way of saying, hey, we don't need trial, judge, just look at all of our documents and tell us if we win. If that's been filed, some judges are even going to say it's too late. So that's why I say the sooner you can do it, the better. But even if you've been in the case 6 months and it's just kind of, languishing there, you could file it at that point in most cases.
Interesting. Okay. So oftentimes you can file it pretty late, but earlier the better.
Yeah.
Okay. Yeah, that sounds great. Well, let's go ahead and take a look at the next question here. What happens after a motion to compel arbitration is granted?
It's a good question. So it depends a little bit on what the court does. Some courts will actually dismiss the lawsuit. They'll dismiss it without prejudice, meaning it could be refiled again. Other courts will just stay the litigation. They'll say, we're going to put an order in place. We're going to give you 90 days to go initiate private arbitration. And if you don't do it, then we're going to allow this lawsuit to go forward. In Arizona, where I practice, I see more of the latter. I see more of the courts putting a stay in place where they stop the lawsuit from going forward. And then they tell the parties, okay, go initiate arbitration. And if you do that, then we'll go ahead and dismiss it. So the question is, and this is something I've had kind of evolving approaches to. I used to take the position of, look, okay, American Express or whoever I'm litigating against, the court said we're going to do it through arbitration. Go file it. You're the one that has the claim against me. Why would I go file it? And they don't do that. they just sit there and say, no, we're not going to do that. And then they go back in 90 days and say, hey, judge, you might as well. They never initiated it, so let's litigate this thing. And I would always take the position, why would we file it? They're the ones with the claims, not us. I have changed my position. If my motion to compel arbitration is granted, I go out usually same day, next day, and I use AAA for most of our arbitrations. I go out and initiate it. It's a very simple process on their website. They make it very user and consumer friendly. And it's something where you can initiate it just to get a case number open. And then I notify the court that I was in, hey, we filed it. I file a little notice. It says, notice of initiation of private arbitration, just so the court knows that I'm doing what they said we could do. And then from there, the company, like American Arbitration Association, they will send out instructions to the parties about any documents they need and about what their processes are. So that's typically what you're going to see once the court grants the motion to compel.
Okay, so most recently you've been filing a motion to compel arbitration, and then the judge will oftentimes grant a stay, which means like they pause the lawsuit, and then you found the collectors were reluctant or like didn't want to initiate. So now what you oftentimes do, you'll initiate AAA arbitration through AAA's website and get that process started. My understanding is the initiator pays a small fee, but then the arbitration clause determines who will pay the arbitration cost, right? There's an initiation fee, but then there's arbitration cost. Is that right for AAA?
Yeah, and you can actually, if you go to the AAA website, and this is American Arbitration Association, not AAA, who fixes your tires on the side of the road.
Right.
So American Arbitration, if you go there, they actually have right on the homepage, they have a link to their fee schedule, and they have different fees based on the type of case it is. So this is a consumer case, if you're doing debt collection, and it will actually outline what the filing fees are. So I believe right now for the consumer to initiate it's $200. And then for the business, for the creditor, I believe the initial filing fee right now is $2,500 or $3,500 for them to initiate, or for them to just to get in. They have to pay that filing fee. And then when you have and hold the actual arbitration, you have to pay for the arbitrator. And typically the rules, and it's American Arbitration Association rules, not the credit card agreement, requires that the business, the creditor, pay for the arbitrator's daily fee. Most of these things are done within a few hours, and so the fee can be anywhere from an additional $500 to $1,000 on top of that. So it outlines who pays what, and that's one of the big reasons they usually don't want to initiate, because it's a huge, they're putting out quite a bit of money to proceed there. But that's pursuant though to their rules, to the American Arbitration Association's rules, or JAMS is the other company that a lot of people use. They have similar things where the filing fees are not equal. The creditor is going to pay more.
And even if the creditor wins, they still have to pay that fee. They can't like wrap that into a judgment against or like an arbitration agreement against the
Typically, no, they can't. And part of this is to go back and look at your arbitration clause. I did an arbitration, I was telling you, like about a month ago, and the terms of that agreement stated that the creditor would pay for all of the arbitration fees unless the arbitrator found that the consumer had essentially proceeded in bad faith. That they didn't, that there was some kind of they were just trying to waste time kind of thing. The arbitrator came back and said, no, you presented some defenses. That particular case, the arbitrator ruled against us as far as the underlying claim, but they said they were legitimate defenses. They just felt that the evidence was more in favor of the creditor in that case. And so they said, no, you're going to have to cover your own attorney's fees, your own court costs, as well as the arbitration fees that were wrapped up in it. So that can be based on the arbitration agreement, not so much the AAA rules.
So with this arbitration strategy, sometimes it almost seems too good to be true. In what situation will a collector try to pursue collection through arbitration? Or is it just the situation where the consumer is going to win every time if their debt is around the same amount as the arbitration fee, like around that $2,000 or $4,000 range?
Yeah. I mean, I always do say this. My little caveat to this is if you're going to pursue arbitration, there are many reasons to pursue it. One is it's a much more consumer-friendly environment than most judicial systems. Rules of civil procedure, rules of evidence, they trip up attorneys all the time, let alone someone who's not working there, on a day-to-day basis. Arbitration is much more relaxed, user-friendly, and so that could be a reason. It could be a reason that most of the hearings are done via Zoom. It's just a much more informal process. So you need to, if you're going to file a motion to compel, you need to do it in good faith. And what I mean by that is you need to be prepared to move forward with it. You're not just using it as an overall tactic to get your case dismissed. But I can tell you this, just based on my experience, obviously, if you're being sued for $4,000 and the court tells you can go to arbitration, the creditor, that's going to play a role, obviously, in whether they want to participate in arbitration. They're going to pay $3,500, $4,000 in the hopes of getting an award of $4,000. And not only that, if they get the award, they then have to go and essentially kind of domesticate it in the court hearing, because an arbitration award from AAA is not something you can garnish wages with. They actually have to go through and get the court to, put their stamp of approval on it as well. So those are the kind of considerations. It's something where sometimes the law firm that's handling it, they have their own preferences. Most collection law firms, they handle gigantic volume, and this kind of throws a wrench into their system because they usually don't have a lot of attorneys handling it. That could play a role in it. They're much more likely to come into arbitration and deal with it if you're being sued for $50,000 as compared to $2,500. But those are some of the considerations I think you need to make as you're deciding, okay, is this something I want to do, is push it into arbitration. It does often lead to settlement or dismissal, but there's also some other reasons as well why it's a decent forum to resolve these disputes.
Okay, great. What elements must the judge consider to decide whether to compel arbitration? Does it just come down to whether there's an arbitration clause in the contract, or is there something else they need to consider?
The ones that if there's not an arbitration clause in the credit card terms and conditions, I don't usually pursue it. This is somewhat state specific. Arizona has case law on it. I think most states are very similar that state, look, this is part of the contract. You're not asking the court to invent something for this. You're just saying, this is, whatever, Citibank's contract. We want to enforce it. You're trying to enforce their own terms. And it works as well, even if you're dealing with a junk debt buyer. Junk debt buyer, they're saying, hey, we purchased, or this account was assigned to us. They've stepped into the shoes of that original creditor, and they are bound by those terms as well. So, but most judges, it's always a little bit concerning to me when judges deny it, because it is what it is. It's very clear that the parties can elect to do that. And so I always say, it's something, it may be even more something appealing if a court denies that, because the contract, most of it is pretty clear cut. Any dispute can be resolved through private arbitration. As long as you're doing it timely, you're not waiting too long, the court should grant it, or at least a minimum stay the litigation to give you that opportunity.
Okay. Great. All right, John, thanks for giving us the rundown on the motion to compel arbitration. We got a lot of questions here in the chat, so let's go ahead and try to get to some of these. Let's see, we got a question from Rent Your Plants. Hi, I filed a motion to compel arbitration and received a response from the law firm saying, quote, plaintiff's limited opposition to defendant's motion to compel arbitration and to stay proceedings. Sounds like that's the title of the document maybe that the plaintiff filed. And Rent Your Plants is wondering basically what they should do next or what that means.
I mean, without seeing the entire response, usually the limited response, when I see that, that's them saying, okay, we're fine with that, but they've got to do it within a certain time period. They've got to, that you as the consumer need to initiate this within that 90-day window. Usually when I see the full objections coming to the motion, it's if you're requesting a motion to dismiss and compel rather than just to stay the proceeding. So the limited objection, I think that's their way of saying, we agree, it's in there, the clause is in there, but judge, you've got to give them a limited amount of time to be able to pursue this. So that would be my guess without actually seeing the document.
Okay, great. Question from Glenn. Hi, the court accepted the motion to compel arbitration even though the plaintiff filed a motion trying to fight it. Once I file with the AAA for the arbitration, how long should I give the plaintiff to basically respond, it sounds like?
AAA will do that for you. Once you submit, they're going to request some documentation. They're going to request when you go on their website, it literally up in the top right-hand corner will say start a case. And they're going to have you upload that credit card agreement that has the arbitration clause, because someone's going to look at it there to make sure that it is, they are subject to it. And then once you do that and you pay your filing fee, they will assign a case manager to your arbitration, and they will kick an email out to you as well as the other attorney and give you some deadlines, give them their deadline to pay their fee, and really start the process going from there. So your case manager will communicate with you frequently, telling everybody what's exactly needed for the case to go forward.
Fantastic. Question from Kira. She just mentioned that AAA will reach out to you. She said she's going through that right now, so that's great. Question from Bosi. I was sued by a debt collector. I filed an answer to the complaint, and I sent a verification letter to the debt collector that they ignored. Can I file a motion to compel arbitration to get that case dismissed from court?
Yeah, I mean, the two issues there, I do see this fairly frequently. I'll just touch on it briefly. The verification letter, once a lawsuit is filed, and particularly once you file an answer, that's really not going to play a role in this at all. The verification letter is usually a pre-lawsuit, pre-litigation type thing. So as far as you can still file the motion to compel arbitration at this point. Like we were saying earlier, the time frame under most arbitration clauses, as long as trial hasn't started or judgment's been entered, it's still going to be timely. And again, the sooner the better, but it sounds like you still have time to do it.
Fantastic. Okay, we got a little bit of a question from Kira. Navy Federal filed directly to the Superior Court, indicated that they served me in 2023, and they never did. I didn't receive the complaint until a year later, and they had my email address on file. I filed a motion to vacate and filed with the AAA, and they didn't sign. They went silent. Oddly enough, it's the same law firm with a AAA claim with BMW. How do I get this out of the Superior Court? They breached their own agreement.
If a default judgment's already been entered, you're going to have to get that set aside by the Superior Court before you're going to be able to push the matter into arbitration. The service of process is a valid basis. The burden's going to be on you to show that the service didn't happen appropriately. And so you're going to go in there and file a motion to vacate with the Superior Court and let them know, hey, I wasn't served. You have to show them and prove that you weren't served, which is always hard. You're kind of trying to prove a negative there, prove that something didn't happen. But if you can go there with evidence saying, look, I didn't even live at this address, or I was out of town, or some kind of proof like that, get the judgment set aside. It doesn't eliminate the lawsuit. It just unwinds it back to the point where you can either file an answer or file your motion to compel at that point. So AAA is not even going to get involved until you get that judgment set aside, because as far as the court and AAA is concerned, it's a done deal right now, and you need to get that unwound, I guess I should say, before they're going to do anything.
Great. Question from Camille. The court rejected my motion to compel arbitration because I didn't submit the answer and the response portion. Can I ask the judge when I show up in court?
I mean, most courts require motions to be written. Again, you could do an oral motion, but something like that where the other side may want to file a response, I would file a written motion. If the court denied it and they, like here, they outlined it some technical defect or something, or they wanted you to file an answer first and then file it, it sounds like something that you could probably remedy. So I would file it in writing. It's unlikely a court's going to grant an oral motion like that, just because the rules usually provide the other side gets an opportunity to fully respond, and you really can't do that if you're just in a court hearing. And my concern too is a lot of the hearings nowadays, the only time you show up to court is at trial, and it might be too late. So I would do it before you get to any type of in-person hearing.
Okay. Question from Michael. Michael. I have been sued by Barclays for $4.6K and have already responded using SoloSuit. I have not yet contacted their attorney regarding a settlement or payment plan, and I have a status scheduling conference / case management conference scheduled for May 28th at the local Ohio Municipal Courthouse. I am currently judgment proof and between jobs. Should I seek to compel arbitration, and is it too late for this? What is my best strategy for a low lump sum settlement of 30% or less?
I always say, I mean, part of your settlement strategy is obviously coming up with what I call your settlement budget, what you can actually afford to offer. And I can say in most jurisdictions, there's not a lot of downside to submitting some type of settlement offer. The rules of evidence, it's Rule 408 in most jurisdictions, state that settlement offers are essentially not admissible in court. So it's usually not something where if you go in there and say, hey, if you go offer them $1,500, they can run in and say, Judge, look, they already offered $1,500. Clearly they owe the whole thing. They can't do that. So there's not a lot of downside to offerings like a settlement. If you file a motion to compel arbitration, and the creditor, particularly on a matter like that, that's a little over $4,000, they may not want to litigate in that forum. They know that there's a contract there that requires them to do that. They may, once you file your motion, they may be more open to a lower settlement of under 30%, like you're talking about. So I think not a bad strategy would be to file your motion to compel. If the court grants it, reach out to the other side and say, look, we can either go to arbitration and deal with this, or I'll offer you the $1,500 that I think I can afford, and see if they're agreeable to that. And if not, then you can proceed with the arbitration and resolve it that way. But it may be something where you're creating essentially a little bit of leverage for yourself, that it's more cost effective just to resolve it through settlement for both sides rather than to resolve it through arbitration.
Okay, great. Michael, the main thing I'm honing in on here is you say you're currently judgment proof because you're between jobs. I definitely want to highlight the collector certainly isn't going to think you're judgment proof if you're between jobs. Judgment proof, by my definition, someone's only judgment proof if they have no income or assets right now, and they will never have income or assets ever again in their life. Because if you lose this lawsuit, the collector will get a judgment against you. Judgments are usually good for 10 to 20 years before the statute, before they expire. And in most states, they're infinitely renewable. So all the collector has to do is just file a document with the court after 10 years, like the day before 10 years expires, and then the judge will renew the judgment, and then they can collect on that for another 10 years. So only if you'll never make money again will you be judgment proof. So that's an important note. So I think definitely taking John's tips here will be a good move, or it can be good in getting this wrapped up. All right, folks, we are half past the hour, so that's when we end. John, thanks so much for coming on the show. I don't know if anybody noticed, but you got the BYU helmets behind you. That's great. I don't know if anyone recognized John. He used to play for BYU Cougars back in the, what was that, 2000s? Is that 90s?
Way back in the 1900s. Yeah, back in 1900s.
John was playing for the Cougars. All right, you can watch them in the, what is it, the Big 12 now? Is that what it is? Big 12?
Yeah, they're the Big 12. Back then, we were the Mountain West Conference, though.
There we go.
And I even played in the WAC for part of my career. Right. So that's how old I am, that it was the old days. But right. That's my last claim to fame. It's been all downhill ever since then. But
hopefully we have some Cougar fans on the show today. The real question is, John, is it you get the Cougar tail or the kettle corn? It's the real question.
Cougar tail. You gotta go with Cougar tail. I mean, look at me. I'm a Cougar tail guy.
Cougar tail. There you go. True blue. All right, folks. Right. Thanks for coming on. Until next time, we do the webinar just about every week. So thank you all for showing up, and we wish you the best of luck. Take care.